On the morning of 30th August 2000, at approximately 9:04 a.m., emergency services in Palmerston North, New Zealand, received a call from 30 Karamea Crescent reporting the discovery of 2 bodies. The caller, Glenn Weggery, had entered the residence through an open ranch slider door and found his sister, Christine Lundy, aged 38, and her 7-year-old daughter Amber, dead from severe head trauma. Police log CS300800 documents the call timestamp and initial response dispatch. The previous evening, phone records showed Christine had purchased McDonald's meals at 5:43 p.m. Mark Lundy, her husband, had checked into the Foreshore Motor Lodge in Petone at 5 cows p.m., approximately 150 kilometers away. Court documents would later establish that brain tissue matching Christine's DNA was found on a shirt belonging to Mr. Lundy, discovered in his vehicle. What investigators would piece together over months was a timeline measured in minutes, a sequence of calls, movements, and forensic markers that would define the case for 2 decades. On the afternoon of 29th August 2000, Mark Lundy departed his Palmerston North home at 30 Karamea Crescent at approximately 3:15 p.m., driving his 1998 Ford Fairmont EL sedan toward Wellington for business meetings. The kitchen sink wholesale business he operated with Christine had accumulated debts exceeding $140,000 to their primary supplier, and Lundy had scheduled meetings in the lower North Island to discuss vineyard land he'd purchased in Hawke's Bay. His itinerary, documented in business records and phone logs, showed a pattern familiar to the traveling salesman: calls to suppliers, stops at petrol stations, nights in budget motels. That morning, Christine had worked at the family business office, while Amber attended Owapuni school. The household routine, breakfast dishes in the sink, Amber's schoolwork on the kitchen table, reflected an ordinary Tuesday. By mid-afternoon, neighbors would later tell police the garage door at the Lundy residence remained closed, the family car parked inside. The normalcy of that departure would become central to investigative reconstruction. What appeared routine was, in procedural terms, the last verifiable moment when the family's documented activities aligned with witness observations. By 5:00 p.m. that evening, motel records at the Foreshore Motor Lodge in Petone confirmed Mark Lundy's check-in, logged at 17:05 hours. The guest register, later entered as Crown Exhibit 47, showed his signature and vehicle registration. The room key was issued for Unit 8. At 5:30 p.m., phone records documented an 8-minute call from Christine, or Amber, to Mark's mobile phone, with cell tower data placing the phone in the Petone area. During this call, according to Lundy's later statement to police, he was told they were going to McDonald's for dinner. At 5:43 p.m. in Palmerston North, a till receipt from the Cloverley McDonald's, recovered from the Karamea Crescent home kitchen, showed a transaction for 2 meals, 1 adult Happy Meal and 1 child's meal, totaling N11.85 baht-hours. The receipt would become Exhibit 12 in the Crown case, anchoring the last confirmed meal time. Neighbors interviewed by Detective Sergeant Ross Grantham reported seeing no unusual activity at the Lundy residence that evening. The garage door remained closed. No vehicles were observed entering or leaving. In the motel in Petone, Lundy's documented presence established one fixed point in what investigators would later term the timeline window. The divergence between his location and the family home, 150 kilometers of State Highway 1 and secondary roads, became the geographic baseline for all subsequent analysis. At 7 p.m., phone records logged a call to Christine Lundy's home landline at 30 Karamea Crescent from a friend, later identified in court testimony as a routine social contact. The call lasted 3 minutes. This represented the last documented communication from the Palmerston North residence that evening. At the Lundy home, the family computer, a desktop PC located in a spare bedroom, showed system activity until 10:52 p.m., when an automatic shutdown was recorded. Forensic computer analyst testimony from the first trial in March 2002 would later state that the shutdown log appeared altered, with the system clock manipulated to suggest the computer had been in use at that late hour. The expert witness declared, "The timestamp is inconsistent with standard shutdown behavior." Meanwhile, forensic pathologist Dr. James Pang's autopsy report, dated 3rd September 2000, estimated Christine and Amber's time of death based on stomach contents as approximately 1 hour after last meal, placing death around 6:45 to 7 p.m. based on the McDonald's receipt timing. The scene that would be documented the following morning showed extensive blood spatter. More than 150 droplets of brain and tissue matter on the ceiling and walls of the master bedroom where Christine's body lay, and Amber's smaller form in the doorway. The contrast between the routine evening phone call and the violence that followed marked the point where ordinary domestic records became forensic evidence. No emergency calls were logged, no neighbors reported disturbances. The house on Karamea Crescent remained silent through the night. Prior to 29 August 2000, court documents revealed that the Lundy family business was under significant financial strain. The kitchen sink wholesale operation owed more than $100,000 to their primary supplier, with additional debts bringing total liabilities to approximately $140,000. 5 days earlier, on 25 August, Mark and Christine had signed an agreement with insurance broker Bruce Parson to increase Christine's life insurance coverage from $200,000 to $500,000. However, Parson's testimony at trial clarified that the increase had not yet taken effect. The policy documents had not been issued at the time of Christine's death. Additionally, in early 2000, Mark Lundy had unconditionally purchased 2 plots of bare land in Hawke's Bay for a vineyard development project called Salu Vino, missing multiple settlement deadlines and accruing penalty interest of approximately 14%. The final payment deadline was 30 August 2000, the day the bodies were discovered. These financial pressures, documented in bank records, creditor statements, and court filings, provided what prosecutors would later term institutional context for motive. The insurance policy, though not yet active, and the mounting business debts formed part of the Crown's circumstantial case, establishing what the prosecution characterized as financial desperation. On the morning of 30 August 2000, at approximately 9:00 a.m., Glenn Weggery arrived at his sister's home at 30 Karamea Crescent to discuss a business matter. Finding the front door locked, he entered through an open ranch slider door at the rear of the property. The house was unusually dark and quiet. In the hallway adjacent to the master bedroom, Weggery discovered Amber's body lying face down, her head severely fractured. Moving into the bedroom, he found Christine on the bed, covered in blood, with additional blood and tissue matter on the wall and ceiling nearby. He immediately dialed emergency services. Police dispatch logs record the call at 9:04 a.m. In his statement to police, documented in the case file, Weggery stated, "I walked in and I knew something was wrong. The house was too quiet." First responding officers arrived within minutes and secured the scene at 9:11 a.m. The victims had sustained multiple blows to the head, from what forensic pathologist Dr. James Pang would later determine was likely a tomahawk or small axe, a weapon that was never recovered, despite extensive searches of the property, nearby waterways, and surrounding areas. Blood spatter analysis indicated Christine had been attacked first while in bed, and Amber had likely witnessed the initial assault before being struck herself in the doorway. The investigative direction shifted immediately from routine police work to homicide response protocol. Scene documentation began with photographing the bodies in situ, mapping blood spatter patterns, and collecting preliminary evidence samples. Within 7 minutes of the 9:04 a.m. emergency call, the first patrol officers from Palmerston North Police Station arrived at 30 Karamea Crescent. At 9:37 a.m., Detective Sergeant Ross Grantham, the officer who would lead the investigation designated Operation Winter, secured the residence and established a crime scene perimeter. Grantham's log entry, time-stamped on 9:37:14, initiated the formal evidence chain. The forensic examination team arrived at 10:00 a.m. and began systematic documentation of what would become one of New Zealand's most forensically complex murder scenes. The crime scene report, later filed as document CS 2000-089, detailed over 150 distinct droplets of blood, brain tissue, and bone fragments concentrated on the ceiling and walls of the master bedroom, with additional spatter extending into the hallway. Investigators photographed the scene at 10:12 a.m. Photograph CS 30-08-0012 shows the positioning of Christine's body and the extensive tissue matter on surrounding surfaces. Evidence collection proceeded methodically. Swabs of blood samples, fabric fibers from the carpet, a jewelry box later determined to be missing from its usual location, and fingernail scrapings from both victims. Under Christine's fingernails, forensic technicians recovered 21 hairs, 10 under the right hand, 11 under the left, suggesting a struggle with her attacker. These hairs were placed in 2 plastic evidence bags and logged for DNA analysis at the Institute of Environmental Science and Research, ESR. The procedural protocol for homicide investigations required complete scene documentation before body removal. This process continued until 2:30 p.m. In the context of standard investigative procedure, these initial hours established the evidentiary foundation. The violence was evident. The perpetrator's identity remained unknown. At 11:15 a.m. on 30th of August, while forensic teams worked the murder scene at 30 Karamea Crescent in Palmerston North, police in Petone located Mark Lundy's Ford Fairmont EL, parked on the street near the Foreshore Motor Lodge, not in the motel's parking lot as would be customary. The vehicle was photographed in place, then transported to Palmerston North Police Station for examination. Detective Inspector Sean Hanson conducted the initial vehicle inspection, finding a black gym bag on the rear seat containing clothing items, a striped XXL polo shirt, green tracksuit pants, underwear and socks. The polo shirt would later become central to the forensic case. That same morning, Lundy had stopped for fuel at an Eltham service station at approximately 8:25 a.m. while driving back to Palmerston North after receiving notification of police presence at his home. The fuel gauge reading, documented by the attending officer, showed 10.1 litres remaining in the 68-litre tank. Subsequent vehicle forensics analysis would calculate fuel consumption rates. Police later determined that a 1999 Ford Fairmont Ghia, similar to Lundy's model, consumed approximately 12.5 litres per 100 kilometres in city driving and 7.6 litres per 100 kilometres on open roads, according to Ford specifications. The prosecution would later argue these figures were crucial to establishing whether Lundy could have made a return trip from Petone to Palmerston North during the evening of 29th of August. Independent analysis by police in October 2001, using an identical Ford Fairmont EL, showed that recreating Lundy's documented business movements plus a theoretical return trip to Palmerston North required 76.1 litres of fuel, approximately 8 litres more than the tank's capacity. The vehicle examination, logged as procedural evidence collection, introduced what would become known as the fuel consumption timeline question. In the afternoon of 30th August 2000, at 2:45 p.m., Detective Sergeant Grantham convened with forensic pathologist Dr. James Pang to review preliminary autopsy findings on Christine and Amber Lundy. Dr. Pang's formal report, completed and dated 3rd September 2000, included critical observations about stomach contents and estimated time of death, based on the McDonald's meal consumed at approximately 5:43 p.m., as documented by the till receipt and the partially digested food still present in both victims' stomachs. Pang initially estimated death occurred approximately 1 hour after last meal, placing the time around 6:45 to 7 p.m. on 29th August. This gastric content analysis, a standard forensic methodology, became the prosecution's temporal anchor. Investigators then cross-referenced this estimate with Mark Lundy's documented movements. A phone call from the Petone Motel area at 5:30 p.m., 8-minute duration with Christine or Amber, and a subsequent business call at 8:28 p.m. from his mobile phone, again with cell tower data, placing him in the Petone vicinity. The investigative hypothesis began to crystallize. If the murders occurred around 7 p.m., Lundy would have had to depart Petone shortly after 5:30 p.m., drive 150 kilometers to Palmerston North, commit the murders, dispose of evidence including the murder weapon and blood-stained clothing, and return 150 kilometers to Petone by 8:28 p.m., a window of 3 hours for a 300-kilometer round trip, plus the time required for the attacks. Grantham's case notes, entered into the Operation Winter log at 3:15 p.m., recorded the formation of this timeline theory. The feasibility question, whether such rapid transit was physically possible, became the central investigative focus. Mapping software calculations showed the driving time at legal speeds would require approximately 4 hours total, excluding time at the scene. The investigative direction narrowed to travel timeline analysis and forensic verification. By 15th February 2002, 18 months after the murders, the Crown prosecution had assembled a comprehensive case file for trial. Among the digital evidence was the home computer shutdown log from 29th August 2000, showing the system had been turned off at precisely 10:50 p.m. Computer forensic expert testimony presented during the trial's opening weeks in March 2002 at the High Court of New Zealand in Palmerston North indicated that the computer's internal clock had been manually altered. The expert witness, whose report was filed as Crown Exhibit 78, stated in the witness box, "The timestamp is inconsistent with standard shutdown behavior." The system registry shows evidence of manual time adjustment. This finding introduced the theory that someone had attempted to create an alibi by suggesting Christine or Amber had been using the computer at 10:52 p.m., well after the Crown's estimated time of death around 7:00 p.m. If the computer timestamp were accurate, it would place at least one family member alive at a time when Mark Lundy had a documented alibi. He was with a sex worker at the Petone Motel, who confirmed his presence from approximately 11:36 p.m. to 12:48 a.m. on 30th August. The computer evidence thus became contested ground, the Crown arguing it was manipulated, the defense maintaining it supported Lundy's innocence. Investigators logged this as digital forensic evidence indicating potential alibi fabrication, a procedural categorization that moved the case from purely circumstantial timeline analysis to questions of deliberate evidence tampering. The technical testimony required the jury to understand computer timestamp mechanics, registry file structure, and the difference between actual shutdown times and recorded shutdown times. The complexity of this digital evidence layer reflected how forensic investigation had evolved beyond traditional physical evidence into realms requiring specialized technical expertise. On 1 March 2002, during the first trial, the Crown introduced what would become the most contested evidence in the case: forensic analysis of stains found on Mark Lundy's polo shirt. The shirt, recovered from the gym bag in his vehicle on 30th August 2000, had been stored in evidence for 59 days before forensic scientists at the Institute of Environmental Science and Research, ESR, examined it under ultraviolet light, discovering 2 tiny stains on the fabric. Initial DNA testing confirmed Christine Lundy's DNA was present. The stains were then sent to Texas pathologist Dr. Rodney Miller, Director of Immunohistochemistry at ProPath Laboratory in Dallas. On 4 February 2001, Detective Sergeant Grantham had personally transported fabric samples and prepared slides to Miller's laboratory, staying as Miller's houseguest during the analysis. Miller employed immunohistochemistry, IHC, a technique commonly used in diagnostic pathology to identify diseased tissue, to determine the nature of the stained material. At trial, Miller testified via video link from Texas, stating categorically, "The tissue smeared on the shirt is absolutely diagnostic of brain or spinal cord tissue." He described seeing, under 1000x magnification, a tangled network of neurofilament structures characteristic of central nervous system tissue. The prosecution's argument was direct. Brain tissue from Christine Lundy, combined with her DNA on the same shirt areas, could only have been transferred during a violent attack that exposed brain matter. The defense challenged the chain of custody, laboratory cleanliness protocols, and the novel application of IHC for forensic purposes rather than diagnostic purposes. Cross-examination revealed that Miller's laboratory was not accredited for forensic work, though Miller maintained his methodology was sound. The IHC evidence marked a procedural shift from circumstantial timeline evidence to direct physical evidence linking Lundy to the crime scene. This forensic conclusion would dominate both trials. Later investigation revealed a significant gap in forensic procedure. The 21 hairs found tangled in Christine Lundy's fingernails during the post-mortem examination, 10 under her right hand, 11 under her left, were never DNA tested and were subsequently destroyed. The hairs, collected on 30th August 2000 and placed in 2 plastic evidence bags, were sent to ESR for analysis, but remained untouched for 9 months before being returned to police custody in June 2001 without examination. In 2020, investigative journalist Mike White documented this procedural failure in North and South magazine, revealing that after Mark Lundy's 2002 conviction, he had written multiple letters to police requesting that all case evidence be preserved. Despite these requests, police destroyed the hair samples in December 2003. In a submission to the Privy Council appeal in 2013, defense counsel stated, "The bags containing the hairs remained at ESR for 9 months before being returned to police in June 2001 without examination. This evidence was subsequently destroyed in December 2003, despite Mr. Lundy's written requests for preservation." Detective Inspector Mark Hercock, lead investigator at the 2015 retrial, confirmed during testimony that the hairs had never been analyzed. The hair evidence represented a potential alternate line of inquiry. If DNA testing had identified a profile matching neither Mark Lundy nor family members, it could have suggested an unknown assailant. Forensic protocol in serious crimes typically mandates comprehensive biological evidence analysis before disposal. The procedural omission became a contested point in appeals, with the defense arguing that untested evidence contradicted the Crown's certainty about Lundy's guilt. Investigators acknowledged the gap in the record, but maintained that the remaining evidence, particularly the CNS tissue on Lundy's shirt and the fuel consumption timeline, was sufficient for conviction. What had appeared as comprehensive forensic investigation now revealed missing investigative opportunities that could never be recovered. In the retrial beginning 16th of February 2015 at the High Court in Wellington, necessitated by the Privy Council's 2013 decision to quash the original convictions, the Crown introduced new forensic evidence attempting to address defense arguments about the shirt tissue. The tissue samples, which had been fixed in formalin and embedded in paraffin blocks by Dr. Miller's laboratory in 2001, were analyzed using messenger RNA, mRNA testing. This technique, performed by the Netherlands Forensic Institute, NFI, aimed to distinguish human central nervous system tissue from animal tissue that might have been transferred through food preparation or consumption, addressing the defense theory that Lundy, as the family cook, could have acquired animal CNS tissue innocently. The mRNA evidence, using genetic markers specific to human tissue, indicated it was more probable the tissue was human rather than from any of 8 common food chain species tested. During the trial, expert witnesses for both Crown and defense debated the reliability of this technique. Defense counsel David Hislop QC, in cross-examination, challenged the scientific validity of mRNA analysis, calling it novel science that had never been used before, never been used again, in a forensic context. The Court of Appeal, in a judgment issued in October 2018 after Lundy's second conviction, ruled that the mRNA evidence should not have been admitted at trial, finding that the technique required the jury to resolve complex scientific debates they were not equipped to adjudicate. However, the court applied the proviso under Section 385(1) of the Crimes Act 1961, determining that even without the mRNA evidence, the other evidence, the IHC identification of CNS tissue, Christine's DNA, the timeline, and fuel consumption analysis, was sufficient to support the guilty verdict. This procedural ruling reflected how forensic science complexity had evolved beyond traditional jury comprehension, raising questions about the intersection of scientific validity and legal admissibility. Throughout March 2015, as the retrial progressed, extensive testimony focused on vehicle forensics and fuel consumption calculations. The prosecution's theory required demonstrating that Lundy's Ford Fairmont EL could have completed a 300-kilometer return journey from Petonin to Palmerston North on the fuel available. Police analyst Mary Elwood testified that between 24 South August, when the vehicle was serviced, with an odometer reading of 80,529 kilometers, and 30 August, when it was seized, reading 81,159 kilometers, the car had traveled 1,270 kilometers total. However, documented credit card transactions, phone records, and Lundy's own statements accounted for only 847 kilometers of known travel, leaving 423 kilometers unaccounted for. The defense argued these missing kilometers reflected local driving around Palmerston North and New Plymouth during that period, movements not captured in formal records. The Crown maintained they represented a secret round trip to commit the murders. Sergeant Danny Johansson testified about police recreation drives in October 2001 using an identical Ford Fairmont EL, attempting to replicate Lundy's documented route, plus a theoretical return trip to Palmerston North. Driving hard with speeds reaching 140 km/h, air conditioning on full, and aggressive acceleration, Johansson used 76.1 litres of fuel, 8.1 litres more than the vehicle's 68-litre tank capacity. Ford specifications stated the vehicle's consumption rate was 12.5 litres per 100 kilometres for city driving and 7.6 litres per 100 kilometres on open roads. Defence counsel Julie Ann Kincaid cross-examined, pointing out that Johansson's test conditions, high-speed driving, full air conditioning, maximum fuel consumption, did not reflect how Lundy would have needed to drive if attempting to avoid detection. The fuel evidence represented a convergence of physical capacity, mathematical calculation, and temporal possibility. Justice Simon France, in his jury instructions, noted that the fuel consumption question required consideration of multiple variables: driving conditions, vehicle maintenance, and calculation methodologies. The forensic vehicle analysis treated the question methodically, without emotion, precise measurements attempting to establish physical possibility. On 1 April 2015, after 16 hours of deliberation, the jury returned guilty verdicts on both counts of murder. Mark Lundy was again convicted of killing Christine and Amber Lundy. Justice Simon France sentenced him to life imprisonment with a minimum non-parole period of 20 years, the same sentence imposed after the first trial. Lundy maintained his innocence at sentencing, telling the court he would continue to fight the convictions. The case then entered the appellate process. In October 2018, the Court of Appeal heard arguments challenging the admission of the mRNA evidence. The court ruled, in a decision issued that same month, that the mRNA testing had been improperly admitted, finding the scientific technique was not sufficiently validated for forensic application. However, applying the statutory proviso, the court concluded, notwithstanding the inadmissibility of the mRNA evidence, we are satisfied the other evidence establishes guilt beyond reasonable doubt. Lundy appealed to the Supreme Court of New Zealand, which heard arguments in August 2019. On 20 December 2019, the Supreme Court issued its judgment, citation NZSSC 152, dismissing the final appeal. The court's concluding paragraph stated, "The other evidence establishes beyond reasonable doubt that Mr. Lundy murdered Christine and Amber Lundy." The judgment specifically noted that all experts, including those retained by the defense, agreed that the paraffin-embedded tissue blocks from 2001 contained central nervous system tissue, and that Christine's DNA was found in the same stained areas. In procedural terms, this constituted institutional closure of the legal process. 3 separate courts had examined the evidence and reached the same conclusion. Lundy remained in Tongariro Prison, filing in 2021 with the newly established Criminal Cases Review Commission, CCRC, for case investigation. In April 2025, the parole board granted release with strict conditions after finding Lundy was not a credible threat to public safety. He was released on 7 May 2025 after serving approximately 23 years, though his case remains under CCRC review. The investigation files were closed. The courts had delivered their verdicts. The institutional record showed documented resolution, though contested scientific questions persisted. In the Supreme Court's appeal judgment of 20 December 2019, the court revisited the forensic cornerstone of both trials. The decision noted that all experts who examined the material agreed that the stained fabric contained central nervous system tissue. The tissue samples, fixed in paraffin and cut into blocks in 2001 at Dr. Miller's laboratory in Dallas, had been re-examined by multiple forensic pathologists over the intervening years, experts retained by both prosecution and defense. Despite challenges to methodology, laboratory protocols, and scientific technique, the fundamental identification remained consistent across all analyses. The tissue was central nervous system material, and Christine Lundy's DNA was present in the same location on the fabric. That polo shirt, found in a gym bag on the back seat of a Ford Fairmont on 30th August 2000, once an ordinary piece of clothing worn by a traveling salesman, now stood as a documented artifact. Exhibit 47 in 2 trials, analyzed in laboratories across 3 continents, examined under microscopes and genetic sequencers, debated in courtrooms and published in forensic journals. The shirt, preserved in evidence storage, remains the physical link between documented movement, forensic science, and institutional conclusion. What began as two tiny stains, visible only under ultraviolet light, became the evidentiary foundation of one of New Zealand's most forensically complex murder cases, a case that would span 2 decades, multiple appeals, and evolving scientific methodologies, but would ultimately rest on that single piece of physical evidence and the question it posed: how does a husband come to have his wife's brain tissue on his clothing?